Hello, and you're very welcome to episode 6 of The Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
And myself, Mark Tottenham, barrister and editor of Decisis.ie.
And Mark, as you may remember, we shared with our listeners recently the wonderful news that we had entered the Apple Business Podcast charts at number 3. Well, we've had a little wobble. In the latest edition, we're down to place number 4 out of maybe 100 podcasts. It's not too bad. So I think we're kind of holding our own, are we?
If they still consider us a business podcast, I'm delighted to be at number 4.
We don't mind. And thank you to our loyal listeners for sharing. That's what's doing it, I'm told. Connell tells us he's an expert in relation to all of this. It's the sharing and passing it on and letting the world know about it. So we're very, very grateful to our listeners for that. On last week's show, you will remember that we had a fascinating conversation with criminal barrister Catherine McGillicuddy. Using the ongoing Hutch trial as a background, we talked about the Witness Protection Programme and the Special Criminal Court, and I think it was really, really interesting.
Absolutely.
Great response.
Yeah.
I mean, Catherine was just fabulous. All the stuff she discussed. Well, today our focus moves to the legal world of asylum, immigration law, citizenship, and we're delighted to be joined in studio by leading senior counsel Colm O'Dwyer, who's going to talk to us about the laws governing human rights and how they are applied in this jurisdiction. I'm very much looking forward to that. But before we get there, Mark, as always, a very popular segment in this show is your 3 cases that you've identified from the Decisis website. Let's start with a probate case with a difference. This is the case of SM versus SL. This is a decision of Judge Nuala Butler in the High Court, and it involved a deceased who died intestate. And the other significant factor was that he had been legally separated from his former spouse. So the question was, who was his next of kin for the purposes of extracting a grant of letters of administration in relation to his estate?
Yeah, so as you said, the deceased here was married, but very sadly, obviously, the unhappy differences had arisen, and a separation agreement was entered into. However, and sorry, I should say that the separation agreement included a waiver of the right of the spouse to extract letters of administration. However, the former wife or the separated wife then was arguing that the separation agreement wasn't valid. And because she was saying it wasn't valid, that meant that she was also claiming that she still had a right to extract letters of administration to the deceased estate. Now, that was contested by the deceased mother, who was the person who otherwise would be entitled to take out the grant. And an application was made to the what's known as the High Court non-contentious probate list, which deals with
Can I just jump in there? Will you explain for our listeners the difference between a grant of letters of administration and a grant of probate, which is probably a term that people will be more familiar with?
Yeah, so we very often talk about probate as just generally the issues to do with succession law and inheritance. But a grant of probate is given where the deceased died testate, in other words, where they left a valid will at the time of their death. If no will was left, the deceased is described as having died intestate, which means that their estate passes according to strict rules that are set out in the Succession Act, and they're divided as to whether it goes to the spouse or the children, or if there are no spouse or children, to the parents or the siblings, and there's a sort of order of succession.
Okay.
So in this case, the deceased died intestate. There was no will, and therefore the ordinary rules of intestate succession applied. And normally speaking, if the deceased is married, then the wife or the husband, as the case may be, is entitled to extract a grant of administration.
And in this case, Judge Butler found that the mother was next of kin.
No, sorry to correct you.
No, that's okay. Please do, Mark.
What she said was that it was not appropriate in this type of application to determine whether the separation agreement was valid or not. So instead of determining that the mother was the next of kin, she made an order, which is quite common under what's called Section 27(4) of the Succession Act 1965, which is where she determines, she effectively overrides the ordinary line of succession and says that this is the appropriate persons to extract a grant.
So there's likely to be another day out in that case then?
Well, in relation to the separation agreement, it's quite likely, yes.
Okay, very good. Our second decision concerns company directors and whether they should have notified the Register of Companies in this jurisdiction of matters which had occurred in a foreign jurisdiction.
That's right.
In this instance, the directors had managed to stave off disqualification in the UK by giving certain undertakings. However, they were also obliged to notify the Registrar of Companies here of those undertakings and what had happened in the UK. This is the case of In-Re SP Steel Limited, and this is a decision of Mr. Justice Quinn in the High Court.
That's right. So what happens when a company goes into liquidation is very often there is an application by I think it's the Director of Corporate Enforcement, to either restrict or disqualify the directors if it is considered that they haven't properly managed the company. Restriction generally means that you're restricted from being a director of certain companies for a period of 5 years. Disqualification means that you're not entitled to be a director of any type of company for, I think it's a period of 10 years. As I said, this generally happens when it's just determined that the directors haven't managed the company properly. But there is a deemed disqualification that arises in certain circumstances where you have been disqualified in another jurisdiction. And what happened, as you said, is that the disqualification would have arisen in the UK, but for the fact that they had given certain undertakings to avoid disqualification in the UK. However, they should then have notified the registrar, the Registrar of Companies in Ireland of these undertakings, and they failed to do that. So they then had to apply for what's called relief from disqualification, which means that the presumption or the deemed disqualification didn't arise once the High Court accepted that they had effectively been mistaken in failing to inform the registrar and that they had taken out certain other actions to satisfy the...
So they weren't disqualified.
They weren't
effectively. Okay, and that was a very significant decision for them,
exactly,
obviously. Okay. Yeah. Finally, a very interesting family law decision from the Court of Appeal this time, which concerned an application for family relocation. This was a decision of Mr. Justice Collins, Mr. Justice Maurice Collins, who only this week was elevated to the Supreme Court.
Right,
and we pass on our congratulations to him, and we wish him every success in the position. This is a very curious case, Mark. Obviously, it deals with a very emotive issue where the courts have to decide whether children of a separating couple remain with one parent in Ireland or move with another parent to another country. In this case, that decision had been made in the High Court. However, there were concerns about the assessment which the High Court had made, and hence the matter came on appeal to the Court of Appeal.
That's right. This is very much a procedural issue, but the bottom line, obviously, is the issue as to whether a parent can move to another country with the children, which, I mean, we've discussed these before. These are decisions that really no human being should be able to make about somebody else's family, and yet it generally falls to a judge to have to determine this
Now, the assessment here, though, was fascinating what happened, wasn't it?
Yeah, well, what happened here was that as is common enough, the court appointed a clinical psychologist under Section 47 of the Family Law Act, or Section 32 of the Guardianship of Infants Act, which one or the other. The clinical psychologist came up with certain recommendations. What the judge did then was, as is not uncommon, she talked to the children in chambers without the parents or the lawyers present. Now, that is a common enough thing to do simply in order to determine what the wishes of the children are, which is something to be taken in the overall context of what is in the best interests of the children. But what the judge did in this case is she effectively treated some of what the children had told her as evidence, and then determined that she was not happy with the decision of the clinical psychologist or the recommendation of the clinical psychologist. So she refused the application by the mother in this case to remove the children to a third country. The country isn't identified.
In the Court of Appeal, they weren't happy with the way that assessment was carried out.
Exactly.
They didn't necessarily say that the decision that was made was the wrong decision. It was just the manner in which it was carried out. So they wanted to go back to the High Court so that it can be do it all again.
Well, there were two issues effectively. One was that because the parties to the case and their lawyers didn't get to hear what the children had said, that the party is obviously entitled to the evidence upon which the judge makes her decision. And secondly, she did not give sufficient reasons for departing from the recommendation of the clinical psychologist, which obviously is something that a judge does need to do. So the matter was then remitted back to the High Court for a full rehearing.
Very good. So very interesting decision there, Mark. And 3 really, really good decisions. Thank you as always for those. Back in a few minutes with Senior Counsel Colm O'Dwyer.
Silence in the Fifth Court.
Okay, so I am delighted to be joined by Senior Counsel Colm O'Dwyer, who is very well known for his work in the area of asylum and immigration law and human rights. And I think it's fair to say, Colm, you're always on the side of the applicant. And you can only be on the side of the applicant the way the thing is structured at the moment. Isn't that it?
Yeah, I suppose that's correct. Yeah. Usually barristers, when they act for the state in cases, or when they agree to act for the state in cases, have to give an undertaking, but they won't act for applicants.
Yes.
In these particular types of cases.
But I think, well, look, let's go back. We're going to talk all about your involvement in human rights and aspects of the asylum law and immigration law, etc. But first of all, can we go back to where it all began? So, you went to college in Trinity, I believe. Mark got very excited when you came into the room. He thinks he recognises you from those days.
Yeah, well, I certainly recognise him. Yeah, I was in Trinity. I studied, back then it was ESS, but it became, while I was there, BESS, Business, Economic and Social Studies. And I suppose my specialty was economics. I didn't do law at all. It was really only after I finished college, I thought about studying law. I was involved in the student union in Trinity for a year. And for various reasons, I just became particularly interested in law and decided to do the King's Inns.
Before we get to law, yes. There's a much more interesting story than that.
Yes.
Apparently you were a star of Trinity Players and lined out on the stage, thread the boards with one Dominic West. Is that correct?
That's correct, yes. Dominic West was in college at the same time as me.
Very good.
But I may have tread the boards with him, but I certainly wasn't as
all
good
the time
an actor
I've
as
known
him.
you and that wonderful backstory. Anyway, let's get back to the law. So you decided to do the King's Inns. It was always barrister. It was never going to be solicitor, I'd say, Colm, in your case, was it?
Yeah, I becoming a solicitor never really appealed to me. I was always interested in the presentation of cases and the barrister's job as an advocate. I had some experience with barristers during the time I was on the student union, and indeed at one stage with Mary Robinson, it seemed to be the right thing for me to do. And
yeah,
was that through the abortion information?
That's right. Yeah, that was my time there. So,
and were you an elected officer of the student union?
Yeah.
Okay, what officer were you?
I was the entertainment officer.
Oh wow, okay.
But we still, obviously, you still had involvement in the politics of the union, and I was particularly interested in that. The really big issue of the day, the X case, was around that time.
And Spuck v. Grogan, there was a very real possibility at the time that they might actually be imprisoned, wasn't there? Or certainly that was
right.
the perception.
In Trinity, I think it was the union members 2 years before me.
Yeah.
But they were some of the individuals that were involved, and there were others from other colleges as well. So yeah, there was a fear that they would be personally liable.
Wasn't there Coogan versus Spuck as well? He was president of the UCD Students' Union, I remember at the time. Okay, so you come into the law library. Who did you devil with?
I devilled with a man called Mel Crystal.
We've all heard of him.
Yeah, well, I hope so. And he was a fantastic master, very generous with his time and everything else.
Taught you a pugilistic attitude to advocacy, I imagine.
Well, actually, it went a bit further than that. He, for many years, was the head of the Irish
Boxing Association.
And part of my deviling involved going to the stadium to be a corner man on different occasions for fights when he was stuck. So I suppose that was an unusual aspect. So I was actually, I was looking down. Yeah, exactly. Yeah. And so I'm still very good friends with Mel, and I really had a fantastic time deviling and learned an awful lot from him.
My question was...
always grateful to him.
How did you get involved in human rights law? Now, obviously, as you say, being a students' union guy, getting involved in the whole Spuck issue and all that sort of stuff, it probably was directing you. You're going in that direction. But deviling with Mel Crystal, Mel was very much involved in this sort of area. So I suppose it was kind of a natural follow-on. It was an area of law that you moved in as a result of the person you deviled with.
No, it wasn't really... when I was deviling with Mel, it was back in the sort of halcyon days of PI that perhaps, I don't know, it might have been before your time, Peter. I think it might have been.
Absolutely.
But when there was...
Hasn't been halcyon since I got into the law library.
No,
anyway.
this is now pre-PIAB. So there was no PIAB. Almost all cases were dealt with through settlement negotiations by involving barristers and solicitors, and very different environment. There was...
and just for listeners who aren't familiar with the acronyms, PI, personal injuries cases, which were a very large part of the bar up until the sort of early 2000s. And then when the Personal Injuries Assessment Board came in, obviously the result was that there was far less personal injuries work going through the bar, and a lot more, certainly, circuit court cases were settled at a much earlier stage. Isn't that right?
That's right, yeah. When I was starting in 98, it was still a huge area, and indeed in the circuit court at that stage, because he was a junior counsel. And
so can I just interrupt there? Yeah. Was he still boxing in 1998?
No, he wasn't.
Oh, sorry, okay.
Long retired at that
okay,
point.
Sorry,
I saw him recently referred to, because he was a witness in a case.
Yes, of course, yeah.
But he was referred to as a retired boxer, but I think he's been a retired boxer for
a long time,
probably 40 years. But, Yeah, I mean, his was a personal injuries, mainly practice, civil practice, I suppose you might say. So the human rights, I mean, there just wasn't that much of that work around at that time. Now, Mel, there might have been a little bit of it coming along, or I might have seen a small part of it. Really, personal injuries and some areas of commercial law would have probably been more his.
With Celtic Tiger 1, isn't that it? I mean, when Ireland had an increase in prosperity.
Yeah.
Certainly in terms of refugees seeking asylum here. There was always that. There was always a tradition. I remember as a young person, Vietnamese settlers, etc., coming to Ireland. So there was always a tradition. But it was only really with that kind of economic growth that happened post 96, 97, 98, suddenly into the early noughties, that there was a growth in this area and the state had to respond.
I mean, that's how I actually got involved. It probably wasn't really through deviling. It was in the very early days, 98, 99, the numbers of asylum seekers coming to Ireland had risen to the thousands. It had been, for many, in the early 90s, there was maybe 50 or 60 asylum seekers coming to Ireland a year. Unimaginable at this point.
Very different now.
Very different. But that was increasing and increasing and increasing. And in fact, at one point, I think in the early 2000s, it went up to 12,000, having been at only 10 years earlier, maybe 50 or 60 a year.
Yes.
So there was a huge increase, and obviously they had to handle that increase and they had to put processes in place. And when I started doing cases, there were refugee appeals, but the Refugee Appeals Tribunal, which was the precursor to the International Protection Appeals Tribunal, the IPAT that exists now. But there was even a body before that where I first started appearing for applicants in these cases doing their appeals. And it was really just out of interest. There was very little money in it. It was great to get the experience on your own, dealing with clients yourself, taking their evidence and making submissions. And I mean, the numbers were increasing so much that a young person like me who had some time available to deal with them, it came to the stage I was doing 2 or 3 a week in the appeals tribunal. But when they set up the Refugee Legal Service of the Legal Aid Board, I was one of the first barristers on the panel. I think it was barrister number 4. Just really mushroomed at that point into the early 2000s, and to the extent that the other work I was doing, my practice was coming along reasonably well. I mean, this work was skyrocketing, and then you had all of the beginning of the High Court cases.
And can I ask, come 2004, when the EU hugely expanded to the east and all the new member states joined, there was a big influx of immigration, obviously, from the new member states, because Britain and Ireland were the only ones who gave an automatic right of access. Did that coincide also with an increase in refugee applications as well, or is that 2 sort of separate issues?
Well, actually, during that period, I would imagine, this is just from memory, but that the number of asylum seekers probably went down, because you've got to remember, when I started, I was still doing cases about Polish people, Czech people, as asylum seekers. Right. And of course, when they, after accession,
they could come here as a right.
They could come here as a right, so there wasn't really any issue about those anymore. So in fact, there may have been a drop-off in the number of asylum seekers at that point. And I think I said it went up to a height of, the number went to 12,000 at one point. I think that was in the very early 2000s. But it started to decrease quite steadily after that, possibly reflecting economic changes as well and in the country. But what did increase, though, of course, with all of these people coming from Eastern Europe and, establishing themselves in Ireland. I mean, obviously you then had huge issues about free movement and their rights to bring family members and with them, and
the rights to housing and social protection and those sort of issues.
Yeah, exactly. All of those issues were arising, and people, and this is what I know, this is certainly what happened to me, and I know several of my colleagues who were around at that stage. You might have been doing these asylum cases and dealing with asylum or refugee issues only, but suddenly you had this much greater area of immigration, and at that point, what we call EU treaty rights, whereby people are exercising their right to free movement to come to Ireland. Sure. So there started to be a lot of case law around that, and most of that was ending up in the High Court. There were important, significant issues.
Judicial review issues.
And there were judicial review issues, and so myself and a number of other barristers who were, I suppose, working in the general area that at the time started to do an awful lot of that work. And actually at one point, I would say, probably my practice became much more about representing EU nationals rather than are now often termed third country nationals, being, people from Somalia or Africa, other African countries.
Can I come back in there, Colm? Just in relation to an EU treaty rights, that's huge. Yeah. And obviously it's a huge area. And we will talk about migration. But let's go back to asylum just for a second. As a general position, what would you say as somebody who works in this area all the time? Would you say, to use a phrase, that Ireland is a warm house for asylum seekers?
Yes, it has been difficult. I mean, you may be aware. I mean, I think you do have to bear in mind what I was talking about earlier, that we had this massive increase in numbers. We hadn't really got the structures in place to deal with that. We hadn't got the experience. There were bodies such as the Refugee Appeals Tribunal set up, but then they didn't really have the expertise, and it was a tough learning process. So what you ended up with, and what gave rise to a lot of work, I suppose, initially, was you had bodies such as the Refugee Appeals Tribunal making quite bad decisions, and the decision making was quite poor for a number of years. There was all sorts of problems, and the particular issue that kept coming up again and again and again was the assessment of credibility. So you had a body that wasn't a court deciding upon the credibility of applicants, and the difficulty is, asylum applicants, it's very rare you have a proper paper trail or paper evidence of all of this. The real key issue is whether their story was credible, or whether it was credible that they had feared persecution.
And just the legal position is that, if accepting the fact that asylum seekers or refugees come from areas and have to flee their countries often at a moment's notice, they won't have paper, they won't have stuff. So there is a duty to sort of give them the benefit of the doubt if their story is plausible.
Yes.
Generally, isn't that the general legal position?
Yes, exactly. No, that is it. But it almost has to be expected in the majority of cases that there isn't going to be the type of evidence you might expect in a case. If you take a regular case, if you look at the situation of somebody coming from Somalia as a country, in the country they're coming from, it's war-torn in one way or another. There isn't the administration there to produce the type of documents that you might get that would be evidence. It just doesn't exist, or they don't have a government that covers the whole country.
But on the other hand, I mean, I've certainly seen case law where there's been determination that somebody has pretended to come from a war-torn country, where the determination has certainly been that they came from another country that was not a war-torn country, and that they appear to have tried to gain access to the country by pretending to be from a.
Oh yeah, no.
There must obviously be a way of trying to determine whether somebody is kind of claiming to come from X country rather than Y country, and presumably do they use the interpreters? I mean, if there isn't any paper trail at all, what's generally done to determine that?
Well, it is very difficult. I mean, and you're right, of course, I might take a little bit of a different view than many other people. So people might be moving for economic reasons and might pretend that they're Somalian to try and get, obviously, refuge, because that's the only way that they're going to get a status here. They're not going to get a status as somebody who's...
The unfortunate situation, though, is that, I think probably half the population of the world live in something close to poverty, and we are a country of 5 million people. So, obviously the international obligation is to accommodate people who are in genuine fear of persecution rather than fear of poverty.
Yes, that is the way. And the question you were asking, it can be difficult when there is an absence of evidence to actually decide upon those sort of cases. It's not as common as people think, but it is an issue, and you do have to look, and there is a balance to be struck there. In
a previous iteration of this podcast, Mark here, and we know is the editor of the Decisis website, and they did a review of the most consulted Superior Court decisions over the last 10 years, and IR, I think, was at the very top. Are Meadows, and these are the central cases that are in the whole thing, that are in your area of asylum law, and it's to do with credibility and the obligation to try and be fair to somebody who's telling their story, and there isn't the raw data to back up what they're saying. So you have to look at it in a very fair way to see if the story is plausible. But as Mark has said, there are people who are telling tall tales. We know that, don't we?
Yes. I was just trying to explain earlier that there may be reasons they're doing this that might be sympathetic, or we might understand why they might do this. But nonetheless, yes, that's true. But one of the difficulties that arose, certainly in the early days with the Refugee Appeals Tribunal, was that credibility was being repeatedly dismissed for no real reason other than effectively a gut feeling of the tribunal member. There's, I don't believe this guy, or there might be some minor part of their story which, you have to look at often with these cases, you have to look at the story effectively in the round.
Absolutely.
So otherwise they might not tell the truth about, this is my view, but they might not tell the truth about one part of the story for whatever reason. It might be the getting to Ireland. They may have had difficulties with traffickers. They don't want to give away names. They don't want to explain exactly how they may have come here. But does that mean they don't have a fear of persecution in their country? Probably not.
Well, as you say, you've talked a lot about the RAT, the Refugee Appeals Tribunal, but that was replaced. That was replaced in 2015 by the International Protection Appeals Tribunal. And I think the system is better as a result. I mean, let's not comment on whether, what is right and wrong, because I suppose there's two sides in all of these things. But the system is working better as a result of that, I think, isn't it? Yeah.
I think the IPAT has been a positive development. There's been real efforts to improve the system. They introduced, they had international consultants involved. Even I seem to remember they had a well-known judge from Canada who came over here and stayed here for a long period. I think 6 months.
It's a very progressive system. I mean, system is perfect.
I wouldn't go as far as progressive, but they improved the decision making. The big problem was the actual decision making. Even if, clearly we have to accept there are people who are not going to tell the truth, but it was the way in which the decisions were made that was the problem. And you often got decisions very poorly written, very poorly reasoned.
Yes.
And a lot of that has changed. Now you look at an IPAT decision, you will, at least the reasoning appears, they break it down into the different parts. Where do I think the person is actually? So the first thing, the very issue we've been talking about, is the person actually from Somalia? So he speaks whatever language, so that would indicate he might be Somali. So they break that down. Then they go, do I think he's suffered persecution in the past? And they go through whatever evidence there might be of that. He might have a medical report from Ireland saying, he has various injuries that would be indicative of torture. So a very structured decision, which you used to not have in the past. So in that way, it's improved. And of course, the success rates have increased hugely
and the speed,
since that.
And the speed of decision making, has that improved as well?
It has, but if you're talking about the IPAT, it has, but it's still probably too slow. But the speed of decision making in the International Protection Office, which is the first stage, which used to be the Refugee Applications Commissioner, has in recent years, and not just because of COVID, this even predated COVID, has got very bad. You're talking now, they say, or certainly recently enough, that you're talking about a 2 year, in fact, 2 years and 2 months for an IPO decision on your case.
2 years to get an IPO, and then how long again to get to IPAT?
Well, you get into you make your appeal, so you're into the IPAT fairly quickly, but you could be, if it's an oral appeal, and a lot of them are, for various reasons now, are dealt with on the papers, for example, where someone comes from what's regarded as a safe country. But if it's an oral appeal, it could still be 8 or 9 months on top of that. So you could well be dealing with 3 years. By
which time somebody who may have put down roots in the country and, they'd be reasonably well established. And are most of these people living in direct provision pending that determination?
Yeah, if you're in the international protection system, yes, you usually in direct provision. There has been a change, as you probably know, in recent years, that they have the right to work while they're still protection applicants or
That's
asylum
after
seekers.
6 months, is it? Or is that after 6 months?
After
or from
6 months,
the time?
6 months after they apply, they can work. For various reasons, it can be very difficult for them to get work. They may be located in a direct provision centre that's out in the countryside, far away from any employers. Obviously, some of them don't have English, and they may have very limited education. If you're coming from some war-torn countries, you may never have been to school, may only have a very limited ability to read or write, things like that. So there will be a lot of barriers, but nonetheless, they can work.
That right to labour market access, though it came as a result of a Supreme Court decision, wasn't that? And then the legislation followed after that. But can
NHV, that was
NHV, leading case in relation to that. Okay, can I get into a slightly controversial aspect of the whole thing? We've talked about the IPAT, and we've talked about the system that's put in place by the Department of Justice who deals with this. Then we go to the High Court. And the area of judicial review in the asylum area is absolutely huge. There are loads and loads of cases there. There are certain judges that have been assigned on a permanent basis just to deal with asylum cases. Not anymore, which is probably a better thing. Colm, can I say, does every case that fails in the IPAT, are all the cases that go through, are they all potentially, worthy judicial reviews? I'm being a bit controversial here with you, but are they really?
Every case that's refused.
Well, every case that's refused. I suppose what I'm saying
there is no judicial reviews of cases, I suppose, that are success if they're granted.
Yes, of course, yes.
The minister doesn't, or the IPAT office
does it not automatically follow that we'll end up in the High Court
if they're refused? No,
not always, but a lot of them do, don't they?
No, I think, Peter, while you're right, there is a lot of judicial reviews in the area of asylum and immigration now, probably 400 or 500 every year, which would make it the biggest single area of judicial review, if you count them together, immigration and asylum, by a long shot. But I think the number of judicial reviews against the IPAT has probably been decreasing. As I said, the decision making has improved. The decisions are much more difficult to challenge by judicial review because they, at least on the face of it, are logical, rational. You can follow the reasoning. It's actually judicial review is not easy. It's quite difficult. And, to establish that the decision, as you sometimes are in these cases, is unreasonable, it's hard.
Yeah, that's very good. And so you're saying basically that the heading, let's say, in the High Court list is the asylum list, but it's actually really immigration and citizenship and all those other related issues that have arisen. Yeah,
one of the big trends in recent times, for example, has been for mandamus cases, which is a relief you don't often hear about, but a different relief.
Explain that for our listeners.
Well, what's happened, particularly in the last few years, and this, again, predated COVID, but there was a lot of this during COVID, actually, was applications for judicial review, but seeking a relief of mandamus, which is, in these cases, was to make, usually the Minister for Justice, to make a decision. And the reason you'd be asking that they would make a decision is because you'd be saying the delay in making this, for example, naturalisation decision is so unreasonable and unfair to me because this is a very important decision for me. There's no reason. I'm not receiving any feedback. And, I've been waiting 2, 3, 4, 5 years for a decision on this application.
And just to clarify, for any listeners who aren't familiar with judicial review, mandamus is when you're asking to compel a decision maker to make a decision, whereas the normal remedy in judicial review is certiorari, which is where you're quashing an existing decision. Isn't that right?
That's right, yeah. And what happened over the last, certainly 3 or 4 years, there's been a huge increase. And there's up to, at one stage, when I would be doing leave applications, you'd see there might be 8, 9, 10 applications every week.
Yes, okay.
Based
so that was a new development.
Mandamus, and that was a new development. But it just showed, and that would have nothing to do, they wouldn't generally be against the IPAT, for example. They'd be against the Minister for Justice.
Yes, okay. And that's interesting. Now, you're talking about new developments, and I'm sorry, Colm, but they're waving at us behind the window here. We're running out of time. And I have to ask you the big question. Ukrainian asylum seekers. Obviously, in response to the dreadful, dreadful scenario that's taking place in Ukraine at the moment, the country has been very generous, I think, in its response. And it has allowed in a lot of Ukrainians and has facilitated them to get refugee status or to be able to kind of live properly in Ireland and to look after them. How does that sit for you with somebody like yourself who works in the system and who has dealt with people from war-torn countries throughout the world, throughout Africa, Asia, various different places? Do you feel that they're getting better treatment than other refugee applicants who are equally, deserving of treatment?
Well, first of all, it's important to realise, that there is this narrative that we're somehow inundated, that we're taking a disproportionate number of, given our population of Ukrainians, and that just simply isn't true. I saw a figure recently, which I think is correct, which is that we're the 9th in Europe in terms of population. So the proportion of Ukrainians we're taking, so the 55,000 roughly we've taken so far, puts us in 9th place in Europe by population. So we're certainly not, I think the Polish, I don't know the exact figure now, they're certainly, I think the number of Ukrainians who are in Poland at this point is 1.4 or 1.5 million. And Poland in real terms is probably a poorer country than Ireland. And, so yes, I think that the state has done...
What about other nationalities?
Oh, yeah, sorry.
That are not getting the same treatment as Ukrainians?
Syrians and people from Yemen or Somalia, they obviously have the same issues as Ukrainians, but they're not being fast-tracked in the same way.
Yeah, that is actually the point, Mark, isn't it? That one of the issues that's been raised is that international protection applicants, so that's Ukrainians apply for, when they arrive generally, apply for what's termed temporary protection, which is provided under a European Union directive. And so they're almost in a separate, parallel system to what we would normally term asylum seekers, which is now international protection applicants. But when you think about it, the Ukrainians are, those applications that they make fairly much as soon as they arrive, and facilities are placed. At one stage, there was even a facility in the airport. But you're granted your certificate within possibly the same day, within several days, and then you have temporary protection.
Yes.
And that is the equivalent, really, in many ways, and in some technical ways is even better than refugee protection.
Sure.
But on the other hand, you have somebody arriving from, say, Syria, equally at least war-torn, if you want to put it that
Yes.
way, also involving Russians and,
has to go through the system.
But they have to
and
go
prove
through
their
the
case,
system,
yeah.
really difficult. They have to, they have to, what we've talked about already, they have to go through the IPO, they have to go through the RAT. It could take, as matters stand, it could take 3 years to get through that process. In the meantime, you are probably in direct provision, which is, receiving a very small stipend, whatever, 29 euros a week per person, being provided with food, but in very, often very difficult circumstances in these direct provision centres. And you don't have, you're still an asylum seeker. You haven't been granted anything.
Sure.
So you have a very limited rights. You don't have, people seem to think they have access to housing, they have access to all of these social welfare, all these things. That's not true.
No.
You might, if you were working, this is what I was trying to say earlier, when they got the right to work. I mean, obviously, if you work and get a good job, you may have enough wages to be able to enter the rental market and
Yes.
actually rent a place. But that's based on you having a job that,
Okay.
due to the rental crisis, it's still going to be very difficult for
Colm,
people.
I feel we've only just touched on there's so many fascinating aspects to this area of law and the area of law that you're engaged in. Thank you so much for sharing your insights into all of that. But before we go, we have the big question. Your favourite book, legal book? Do you want to mention a legal book to us?
Yes, I got to get that in, and thanks for asking, because I'm going to say 2 books if that's not
Oh, very
too
good.
cheeky.
No, you're allowed. We had somebody who said 4 books once upon a time.
Okay, well, I could give you a few more, but I'll give you 2.
Two'll do.
Many years ago, I had a guy called Dr. Trever Redmond.
I remember Trever well, yeah, absolutely.
Yeah, very, very intelligent man, now in Department of Foreign Affairs, a senior lawyer in Department of Foreign Affairs, but he wrote a book, which I think is a fantastic textbook, called The Law of the EU. So that's Trever Redmond, Law of the EU.
Okay.
It's one of the most recent EU textbooks. It obviously has EU law textbooks. It obviously has an Irish focus.
Trevor was in the law library, as you say, he devilled with you, but he was there for many years.
He was there for a few
wonderful
years.
barrister.
Yeah, and
Second book.
That, I suppose you would say, is an academic textbook. That would be more aimed at students or people interested in the technicalities of EU law. But the second book is Sally Hayden book called My Fourth Time We Drowned. Sally Hayden is a journalist, I think, who has worked for a number of newspapers. Really fantastic, award-winning journalist, but she's written a book about what's regarded as the world's most deadly migration route, which is coming up through Libya to try and get to Europe. So African migrants and asylum seekers trying to get up, and all about the and Frontex and what's been done to try and push, Europe has done sometimes to try and push asylum seekers who may be in these boats back to Libya, and how dangerous Libya. It's an absolutely fantastic read, but horrifying.
So Sally Hayden, The Fourth Time We Drowned, is that it?
My Fourth Time.
Can we squeeze in a movie, Mark? Can we squeeze in a movie?
Do you have a movie?
Probably my favourite movie is, and I'm saying this completely off the top of my head, is probably Goodfellas.
Oh, right.
Yeah, okay.
Oh, yeah.
So I think that has a legal aspect, I suppose.
More of an illegal movie.
I thought you were going to mention your old pal Dominic West. Anyway, there you go. All right, come here. This is fantastic.
I better just. The Wire was a fantastic show.
Come here. Thank you so much for coming in. It has been fascinating, Colm, and thank you for giving us such insights into the world of asylum and immigration law. Colm, thank you very much.
The Fifth Court will adjourn until next week.
So that's all from this edition of The Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guest, Senior Counsel Colm O'Dwyer. And he asked me to mention that he's a commissioner of the Irish Human Rights and Equality Organisation as well. He's a commissioner of the Commission as well. So we just didn't mention that in the intro earlier. But it was wonderful. Colm came in and gave us such wonderful insights into asylum law and immigration, Mark.
Absolutely, yeah. And he's seen such changes over the last 20 years in that whole process.
Yes, absolutely. And I would also like to say a huge thank you to our producer, Conal O'Moroyne, and to the Dublin South Podcast Studios for recording this show and doing such a wonderful job. As always, we put out the message, if you have any comments or if there are any legal stories that you'd like us to discuss and raise, please contact us on our website or on LinkedIn. And Mark, our parting message is always...
Please like and particularly share, whether on Twitter or on LinkedIn or Facebook or wherever you think that you have friends or colleagues who might find this podcast of use or interest.
Thank you all for sharing, because people are sharing, and hence we're registering on these charts for whatever they mean. But it sounds like people are being very supportive of us, and we're very grateful for that. So from myself and Mark,
thank you very much.
And until next time, goodbye.